Welcome everybody, and thank you for coming, especially with this beautiful weather. So thank you this is a continuation of the seminar series on anti-Semitism. We'd like to say hello to Chuck Freelock, who's the co-convener of the seminar series, who's at the Kennedy School here for the semester, also teaching in New York at Columbia and NYU, and is based the security studies in Israel. So welcome. And it's actually thanks in large part to Chuck that this event is happening. So today it's a great honor to have Aleksandra Gliszczynska-Grabias. I'll do the anglicized name. She graduated from the European Studies Department of the Faculty of Law of the Adam Mickiewicz University in PoznaY, Poland. She recently received, she's a recipient of the 2012 Fellowship of the Foundation for Polish Science for the Outstanding Achievement in Science and Research. And this is one of the most prestigious, if not the most prestigious, academic award in Poland. She was awarded by the president of the country himself.
His wife.
His wife. So that was a great distinction for her groundbreaking research. In 2010 and 11, she was a graduate fellow of this place that used to exist. It was a fine place called the Yale Initiative for the Interdisciplinary Study of Anti-Semitism. She was one of our scholars with us, and she was a delight to have with us for the year, so it's nice that she's back, kind of continuing on in our work together. In addition to being at ISA at Yale, she also was a recipient of the 2010 and 2009 Felix PoznaY Fellowship for Doctoral Studies, for a doctoral fellowship at the Vidal Sassoon Institute for the Center for the Study of Anti-Semitism at Hebrew University. And she also is a Rothschild Foundation European Research Grantee. She is currently the senior researcher at the PoznaY Human Rights Center at the Institute of Legal Studies of the Polish Academy of Science, where she has recently defended her doctorate degree on countering anti-Semitism with legal instruments of the international human rights law. Her main fields of research are the legal struggle for against racial discrimination, freedom of speech versus hate speech, defamation of religion, universal systems of human rights protection. Her previous professional experience includes being the co-author of a report that monitors racist, xenophobic, and anti-Semitic instances in the Polish media. This was part of the Polish Ministry of the Interior, and the report was given in 2008. She also did groundbreaking research on notions of sexual orientation for the European Union member states for the EU Fundamental Rights Agency in 2010, and she's co-authored and co-edited books on hate speech versus free speech, legal and social aspects, with Kluwer Publications in Warsaw, and she is the co-author of the first Polish commentary to the International Covenant on Civil and Political Rights in Warsaw 2012. She's prepared many reports and analysis for the Polish Parliament and for the European Commission. Aleksandra is also the Vice President of the Open Republic, an association that fights against and studies issues of anti-Semitism and racism, and she's which is a leading Polish non-governmental organization active in the field of fighting against intolerance and hatred. And that's just the tip of the iceberg. So it's really great that you're here. Thank you.
Good evening. I would like first of all thank ISGAP and thank ISGAP Director Charles Small, whom I have a pleasure to collaborate with, for inviting me to speak here at Harvard Law School. It is a great privilege and an honor. The topic of my paper suggests that it deals mostly with the past, but actually the implications of memory loss are first and foremost about the present and the future. And only a few days ago, when I was preparing for this presentation, I found out that the French Parliament is now again working on the new bill on Armenian genocide denial. It means that the new tensions and new problems between France and Turkey are to be expected very soon. And this is just one example which demonstrates how memory loss on the events concerning events that happened 100 years ago are influencing today's political and legal situation. Let me start by the description of the concept of memory loss. History, memory, and national identity are phenomena which are not easily captured by the language of law. Nevertheless, the legislators of many European states, and including legislators of the European Union, have established legal regulations which aim at shaping specific historical memory of European societies. Should such legal measures, defined by some as an example of social engineering, exist in open, democratic, and free societies of Europe, or perhaps these laws, although sometimes limiting the freedoms and rights of an individual, are established for the right cause of stopping those who want to cover up the truth lies, to quote Bob Dylan. Undoubtedly, memory laws are characteristic today mainly for European states, and in the United States, the First Amendment jurisprudence makes it almost impossible to accept memory loss. One of the primary reasons for such a discrepancy in legal attitudes is, of course, the estimated risk of limiting free speech, which such laws are likely to cause. As Wojciech Sadurski puts it in the context of penalizing negationism, in the United States, the groups which feed on the literature, such as historical revisionism, are part of the political folklore, just as are flat earthers and Montana separatists, probably irritating and deeply offensive to many, but very unlikely to reach a capacity to challenge the democratic system to its core. Memory laws are, however, so controversial that even many Europeans oppose them. Members of the Liberty for History associations, and among them such historians as Timothy Garton Ash or Pierre Nora, a few years ago made the famous Appel de Blois, in which they said, history must not be a slave to contemporary politics, nor can it be written on the command of competing memories. We ask government authorities to recognize that they must not establish by law and for the past an official truth whose legal application can carry serious consequences for the profession of history and for intellectual liberty in general. However, the difficult relation between history, memory, and law is a fact, and the challenge it poses must be faced with by historians, sociologists, politicians, and also legal scholars. The importance of the legal component of this equation is aptly described by Lawrence McNamara when he says, as law mediates and regulates claims to justice in the present, its grasp of how to deal with the past must be a central concern. There is too much at stake for things to be otherwise. Legal regulations called memory laws have basically two forms. The first one is legal establishment of some official orthodoxy of the past events without, however, any sanctions. And the second is the legal prohibition to deny or to interpret historical events in a specified way under the threat of imposing a sanction, most often sanction of criminal law. And basic legal problems emerge here, as all prohibitions of this kind are inevitably related to human rights and freedoms, limiting them in a way which is not acceptable for many. Furthermore, it is often pointed out that a valid court judgment is a one-off and quick end of the matter, stopping discussion on sometimes extremely complicated problems. Therefore, it is often claimed that such conviction cannot be an element of building a long-term memory and identity of a given nation. As noted by Jim Hogland, Europe is a continent colonized by its past and memory. And it seems that this statement is particularly true with reference to the history of the 20th century Europe, which is expressed, for example, by the growing number of monuments or museums, places, and symbols of commemoration of the past, and also by the memory laws established in the states of the old continent. These laws are most often the expression of the legislator's desire to regulate the difficult problems left over from the past decades, which for many reasons are still the object of disputes and national traumas. One of the most controversial memory law in force now in Europe is the 2007 Law of Historic Memory, introduced by the Spanish Congress of Deputies. The provisions of this law, which include limitations on individual rights and freedoms, concern two aspects. The first one is the prohibition of organizing political events at the Holy of the Fallen, which is Franco's burial place, and the removal of Francoist symbols from the public buildings and spaces. And at first sight, they do not seem controversial or oppressive, at least if one compares them to, for example, Austria's Prohibition Act of 1955, which provided the legal basis for the process of denazification in Austria and aims at suppressing any potential rebirth of Nazism through the penalty of imprisonment for up to 10 years. But although the wording of the Spanish law says that its aim is the recognition of the victims of political, religious, and ideological violence on both sides of the Spanish Civil War and of Franco's regime, its provisions prove that it was designed as a tool of praising and aiding Franco's victims and condemning his supporters. Thus, the law violated the Spanish Pact of Forgetting, legally based in the 1977 amnesty law, and had to be confronted with the split memory of the Spanish society and fierce criticism of the political right. As a result, some consider it to be accusatory rather than reconciliatory. Prohibitions to publicly deny the crimes of communism and Stalinism and display their symbols, such as sickle and hammer or the Red Star, introduced in post-communist countries, are yet another example of memory loss. In the context of this regulation, it's worth recalling the bill on the amendment of the criminal law in Russia, and the works on this amendment started in 2009. According to it, any form of the total or partial rehabilitation of Nazism and Nazi crimes, as well as denial of Nazi crimes, will be forbidden. At the same time, the law would punish for characterizations of any actions undertaken by the members of the anti-Hitler coalition as being criminal, which would in fact criminalize true statements about Stalin crimes committed, for example, in Poland. And from the Polish perspective, such a provision, if introduced, would legitimize with the authority of law an inadmissible historical lie. However, the most frequent legal regulations about different types of historical assertions were established in France, where for years the truth about the colonialism and collaboration with the Nazis was pushed back into the state and social oblivion. And the latest and strongest controversies emerged in January 2012, when both houses of the French Parliament adopted a new law on criminalizing the denial of the genocide of Armenians committed by the Turks during the First World War, with the same penalties as in the case of Holocaust denial. And although the provision was very soon struck down by the Constitutional Council on the grounds of its unconstitutional character in respect to violation of freedom of speech, its implementation by the French Parliament led to a serious conflict between Ankara and Paris. Turkish government from the very beginning fiercely attacked the French initiative to penalize the negation of the Armenian genocide. At the same time, Turkey established and still applies provisions of the criminal code prohibiting the slandering of the Turkish nation and slandering of the state of the Republic of Turkey, which is an instrument used by the authorities against people who deal with the problem of the Armenian population in the Ottoman Empire, as well as the modern forms of these historical events. And in particular, the authorities punished for saying that the events of 1915 were a crime of genocide of the Armenian people. Orhan Pamuk, a world-famous writer and Nobel Prize winner, was among those who were accused by the public prosecutor of such expressions. And this example shows how memory loss can be and dangerous tool of political and historical manipulation. But it also makes us ask a question whether states have the right to pass memory laws related to the events which are primarily part of the history and identity of the different states and nations. An interesting opinion is presented by Rafik Rotanian, who wonders about possible French reaction to Turkey passing a law to criminalize denying the fact that the torture tactics used by France during the Algerian War of 1954 in 1962 was a crime against humanity. He concludes with a very strong pro-genocide denials argument, stating that when a powerful nation like France or Turkey refuses to acknowledge a crime against humanity in their own pages of history, then it is not only up to the world's scholars to investigate the history, but also the world's influential politicians to pass laws which not only consolidate a travesty historical actuality overlooked by the perpetrator country, but will also increase the pressure for the state in denial to accept its wrongdoing and commence the healing process. And even Germany has not escaped serious controversies. Although memory about Nazi crimes committed during the Second World War is maintained there also by the means of law, in the recent years a trend has been observed to emphasize German war sufferings and to make attempts at treating the harm done to Germans and the harm done by them in the same way. And the idea to establish a center against expulsions in Berlin, which commemorates mainly the German victims of the expulsions made during and just after the Second World War, with the support of the German government, was the symbol of this change in political path, according to which all cases of all murders and oppressions are comparable. In 2003, the idea was fiercely opposed by Marek Edelman, the leader of the 1943 uprising in the Warsaw Ghetto. In response to the argument that Germans simply wanted to exercise their right to their own memory of those events, Edelman said, "What sort of remembrance? Did they suffer that much? Of course it is sad when you are being forced to leave your house and abandon your land. But the Jews lost their houses and all of their relatives. Expulsions are about suffering, but there is so much suffering in this world. Sick people suffer and nobody builds monuments to honor them." And the question arises, do Germans have the right to commemorate expulsions which they experienced? Definitely yes. But this remembrance must take into account the historical context. And this short overview of memory laws established in Europe, I think, makes us aware of how divided and asymmetric the memory of European states and nations is, and that the chances for its even partial consolidation are very limited. Let me now examine the case study of Poland, which is an interesting example of a state which, while putting its history on the pedestal of national values, wrestles at the same time with its difficult and often traumatic past, every now and then mixing it with the present-day politics and public life. Living for a few decades under the rule of communism, Poles did not have the chance of leading an open, free debate on history. In communist times, one could go to prison for long years, and during Stalinist times, one could even lose one's life for saying the truth about Soviet secret police murdering Polish military elites in Katyn. At the same time, and to a large extent, in response to this enslavement, the often mythical vision of the Polish heroism was cherished and passed on to the next generations. And this memory stored the identity of the nation, which would regain its freedom in 1989. But before that time, there was no place to review its own guilt. Thus, the memory laws established already in the free democratic Poland must be considered also in this historical context. In 2006, the Polish parliament, with the votes of the far-right coalition then in power, incorporated the new provision to the Polish criminal code, which sanctioned the crime of so-called defamation of the Polish nation by accusing it of involvement in Nazi and communist crimes. To a large extent, this regulation was a proof that the part of Polish society is not capable of accepting the truth, which was described by Jan Tomasz Gross in his books published then, although this truth was unveiled much earlier by eminent Polish historians from the Polish Center for Holocaust Studies. It is the truth about blackmail, extortion, denunciation, betrayal, and plunder of the living and the dead, made by Poles against the Jews in many places in Poland during the Second World War and directly after its end. This provision was found unconstitutional by the Polish Constitutional Court in its judgment of September 2008 because of the faulty legislative process during which it was passed. The court did not, however, take into account the charges concerning the substance of this case, and in this way avoided taking a stand on this socially, historically, and sensitive issue, which is very regrettable, as in a sense this regulation supported the lie with the authority of the law by penalizing for speaking about the Polish involvement in the crimes of Nazism and communism. And it was undoubtedly an example of a dangerous and harmful memory law, which instead of defending the truth, contributed to its falsification from the legislator's wish. There was no Polish peace link or Tisko or Betan. Poland never aided to the Nazi crimes, as did the societies and states collaborating with the Nazis on a large scale, such as Slovakia, Hungary, Croatia, or Romania. And these assertions are true. But there is another assertion painfully truthful. These were Poles, not Germans, who burned alive their neighbors, men, women, and children, in a barn in Jedwabne on a sunny day of July 10, 1941. A law which even indirectly permits falsification of this truth cannot exist, and fortunately does not exist in Poland anymore. So are memory laws more dangerous or more necessary? The opponents of the establishment of memory laws, in addition to the accusation about the excessive restriction on the freedom of speech and academic research, raise concern to a large extent justified about the danger of decreeing by law the history and memory of the nation by those who are in power at the time. A very fragile crew of facts is, as Hannah Arendt described it, not only prone to forgetfulness, but also to manipulation. However, these words can be quoted, I think, and invoked as an argument both for and against establishing of memory laws. But the danger that the law will be used as a tool against memory is indeed significant. Among other arguments against memory laws, we can also mention the fear that the courts will be turned into places where decisions are made about historical facts, and the law becomes instrument of a certain type of social engineering. These and other arguments opposing memory laws have been discussed broadly in the literature of the subject. In the case of such laws as the Polish prohibition of the defamation of the Polish nation, it is really difficult to find reasons of their establishment. However, when it comes to memory laws, which are an expression of the state's readiness to review its past guilt, one can advance arguments justifying the existence of such laws. The first argument is about the necessity to make commemoration of the victims of past crimes a legally protected good. In this case, it is no longer the historical truth that is being protected by the state, but the memory and dignity of the victims of these events, which were crimes against humanity or war crimes or genocide. And this argument is directly connected with the prohibition to offend the human dignity included in many constitutions of European states. There is also another significant argument expressed in the words of Marek Safian, Polish judge of the Court of Justice of the European Union, which he formulated also in the context of the discussion on memory laws in Poland. Safian has noted, human memory is short and deceptive, while the trivialization of lies and hatred disseminated in public space may have destructive effects, particularly for the young generation of Europeans. And in this meaning, memory laws are also meant to arrest the process of obliteration of the memory about past, and in the case of majority of memory laws, about the nature of totalitarian regimes and dictatorships, which resorted to crime. Consequently, democratic order of the state and the foundation of democratic society are also protected. When searching for other arguments in favor of memory laws, one can also make reference to the general concept of the functions of law, which is about the aim of law and consequences of law. And in this context of particular functions performed by memory laws, the following seem to be particularly significant. The regulatory function, when the law contributes to the establishment of the framework of permissible discourse and social behavior. The protective function, focused on the protection of the goods of individuals, including the protection of individuals who are weaker in social dimension or often belonging to minorities. And the educational function, which assumes the impact of law on the promotion of specific values and shaping social attitudes, evaluated positively by the legislator. However, the most problematic and controversial issues connected with memory laws concern two questions. Is genocide denial different? And is Holocaust denial unique? Consequently, one must consider whether regulations which penalize denial, belittlement, or praise of the crimes of genocide are better justified than other memory laws, and whether penalization of the Holocaust denial is justified in an even more convincing way. When it comes to genocide denials in general, legislators of European states recognize that negationism of the crime of genocide is not only harmful to the individual in the individual dimension, but also in the social dimension, and that it also insults the memory of the victims of the crime of genocide. In a broader context, the negation of genocide committed by former or present generation of a given society is often considered to be a proof that this society is not ready to assume responsibility for its crimes. It can also be motivated politically, serve to build the united and shared identity of the nation, like in the example of the French post-war policy of silence concerning the Vichy regime, or to incite hatred to a hostile nation and society, like the Iranian administration against Israel and Jews, of which the Holocaust denial is a central element. Negationism can also be a mechanism used to incite exclusion of minorities and socially weaker groups, their stigmatization as liars who made up their sufferings, which facilitates further oppressions. Many scholars studying the phenomenon of genocide, its conditions and mechanisms, believe that denying this crime is a factor which increases the risk of its return, and that it is one of the elements of the entire process of genocide. There is finally the question of penalization of Holocaust denial. As explained by Tony Judd in a moving essay on European historical memory, Hitler's final solution to the Jewish problem in Europe is not only the source of crucial area of post-war international jurisprudence, it also adjudicates the moral, and in certain European countries the legal, standing of those who pronounce upon it. To deny the Holocaust is to place yourself beyond the pale of civilized public discourse. The legal situation that Judd writes about has been shaped in Europe by the regulations which penalize public dissemination of Holocaust denial. However, is it justified in a more convincing way than in the case of any other genocides? A few arguments may speak in favor of adopting this point of view. Today, the arguments of Holocaust deniers find advocates all over the world, from Ukraine to Japan. The president of Iran makes Holocaust denial an official state doctrine. And at the same time, the last generation of the prisoners of German concentration camps is passing away. As a result, Holocaust denial is nowadays, as defined by Wojciech Sadurski, a part of a larger package of an ideology which maintains that Jews cannot be trusted on anything, even on their own past. The threat stemming from dissemination of Holocaust denial becomes even more apparent when one considers the level of general knowledge on the history of Second World War and of the Holocaust in Europe. The societies and their historical awareness have always been the best guarantors of preserving historical memory. But is it truly the case today? As indicated by a poll commissioned in 2012 by the Forza Research Institute, on January 25th, so just 2 days before the International Holocaust Memorial Day, 21% of Germans aged between 18 and 30 asked about the concentration camp in Auschwitz had never heard of it. Another survey revealed that in 2009, 23% of British secondary school students did not know what happened in Auschwitz. Answers to the questions about this camp of extermination included association with a bread name, a state bordering on Germany, or a type of bread. How should the memory about the Holocaust be defended if education about it fails so dramatically in such states as Germany? It is also worth emphasizing that a specific form of negationism is very dynamically disseminated in some Arab states, which in the context of the conflict in the Middle East can be yet another factor which inflames it. And the negationism present in Arab states has its own character, and it is different from European negationism, but in no way should it be treated as less harmful. What distinguishes it is the assertion that the Holocaust happened, but it was groundlessly used by the Jews to establish the state of Israel, and the desire to deprive the Holocaust of its exceptional character by making Palestinian sufferings equal to the sufferings of the Jews during the extermination. Finally, it must be said that at the time when modern communication techniques, especially internet, are generally used, the scale of dissemination of theories of negationists is simply unlimited. Presently, there are thousands of websites with information about the great Jewish lie, given in the form which suggests that this is a reliable, scientifically proven fact. Denial of genocide never before reached such a degree of international dimension with its own structures, institutions, publications, and Facebook profiles. However, it is the recognition of Holocaust denial as one of the modern forms of anti-Semitism, a type of hate speech directed against the Jews, which, in my opinion, is the main argument in the context of its penalization. Although most often statements denying the Holocaust do not contain openly hostile, hateful, anti-Semitic slogans, for everybody who reads them in the broader context, the anti-Semitic motives of them are obvious. It is difficult to see any other but anti-Semitic motivation in the assertion that the myth of the Holocaust was born out of a Jewish conspiracy. According to Holocaust deniers, devious Jews, greedy of power and wealth, lying about the crime which has never been committed, should arouse mistrust, contempt, and consequently hatred. Therefore, if we assume that Holocaust denial is a form of spreading hatred of Jews and a manifestation of anti-Semitism, legal regulations which would ban its dissemination must be acknowledged as an element of the broader strategy of the state to fight against all forms of racism, national or religious hatred and intolerance. And the European states have undertaken legal obligation in this respect by becoming parties to international treaties such as the International Convention on the Elimination of All Forms of Racial Discrimination. Holocaust denial does not translate into sudden, intense explosions of anti-Semitic moods, nor does it directly lead to acts of violence directed against Jews. However, a strong correlation between words and actions is indisputable, although it is difficult to determine when the critical moment of words becoming actions may take place. Various forms of antagonism may lay dormant for long years, only to suddenly begin to escalate, reaching the proportion of mass psychosis. And the history of the Third Reich, hate propaganda, leaves no space for questioning the influence that the words may have on the deeds. Martin Krieger, talking about the Holocaust, points out that human history is not an overwhelmingly happy story, and atrocities are available in virtually any time and any place. But an enterprise on this scale is extremely rare, perhaps, as many believe, uniquely so. And I am one of those who share the view of the unique character of the Holocaust but who at the same time do not set any scale or hierarchy of the suffering of victims of any genocide. However, it must be emphasized that unlike other genocides, the exceptional character of the Holocaust is manifested also in its being used so broadly and so commonly to resurrect hatred for the reason for which it was committed. And the international human rights law opposes this absolutely. Some concluding remarks. So can memory laws help Europeans to cope with their past and to retain their historical memory and identity? It seems that this question can be answered affirmatively only with respect to the limited group of such laws. The memory of European societies trapped after the Second World War in the domination of the communist regime is not shared or understood by the societies of Western Europe. At the same time, countries like Poland, which were never party to colonialism, do not identify with French laws that regulate this problem. Furthermore, some memory laws consolidate the false identity of a nation based on the belief that one was always only the victim of the crime and never its perpetrator. Such laws must be criticized, and the legislators who pass them take upon themselves the burden of responsibility for the harm which they inflict in this way upon their own society and the future generations. The experience and history of the entire post-war Europe have shown that although some convergence of narratives is possible, there are differences between memories of states and nations which can never be overcome. The consensus about the recognition of the crime of the Holocaust is, and in my opinion, should be an exception. The Holocaust is a tragic heritage of all Europe, and in face of enormous social and cultural changes taking place in Europe today, it is our duty to ensure that the truth about it, which was one of the cornerstones of the new reborn continent, is not forgotten or falsified. Tony Judd wrote that recognition of the Holocaust is a key that opens the door to Europe. However, is this statement still true? Perhaps in the political sense it is. No state aspiring for the EU membership can deny the Holocaust in its official state doctrine. However, at the level of social life, this argument is more difficult to defend if we take into account such seemingly unimaginable facts as cases of abandonment of teaching about Holocaust by schools in European states because of protests of Muslim students and their parents. Should the state faced with such situation respond by means of law? Surely this is not enough. I think, however, that the law, taking into account its functions, should be a component of the whole program of preservation of the memory about the Shoah. I can notice two most important roles which memory laws should play in Europe today in order to find them justified and legitimized. First, such laws should be approved that a given state has assumed responsibility for the crimes and serious violations of human rights in the past done by this state or its citizens. The memory of Poles about the crimes committed against them by Nazis and by Soviet regime is strongly shaped and deeply rooted. Nonetheless, Poles, probably as many other nations, often do not remember about the crimes committed by themselves. This screw is still driven away from the social consciousness, although to a lesser and lesser degree. Second, memory laws should be a barrier to the abuse of the freedom of speech and freedom of research to spread hatred against specific groups. I agree with Konstanty Gebert, an eminent Polish journalist, who say that there is no other way to emerge from the conflict of different groups, including different nations, than by respecting the existence of many memories. However, in some cases, the multitude of memories is only a convenient way of driving out what is disgraceful in the biography of one's own nation. Classification of the Jews in Auschwitz, crimes of the pro-Nazi Hungarian Arrow Cross Party during the Second World War, or the massacre committed by the Soviets in Katyn cannot be remembered differently. If a state adopts legal regulations that sanction this reversed memory, such memory laws should be opposed vehemently. If, however, it is individuals or groups in the state who try to bring this fraudulent version of history into the public discourse, the state must be able to respond also with the instruments of law. And I have not aspired today to convince you about the necessity of establishing memory laws, because this is one of the most difficult and complex issues in the whole discussion on the relation between memory, history, and law. However, I do believe that in some cases memory laws can be an answer to the powerful call of Elie Wiesel. Remembering is a noble and necessary act. The call of memory, the call to memory, reaches us from the very dawn of history. Thank you.
Thank you very much. So we have time for some Q&A. I can start off unless somebody wants to jump in. Go ahead. Should I start? Okay. So thank you very much for your paper. I found it very depressing. Obviously, it's a subject that is not easy, but all of these issues are not easy. But so I have 2 quick points. Stuart Hall, who was a cultural social theorist, said that monuments and memory can also be a tool to show the bigness of the perpetrator, that they've acknowledged their sin. So the monuments and the memory becomes less about the victims, but more about the perpetrators changing their perceptions of themselves. It becomes their bigness and their liberalism, as opposed to the history of the victims. So I think this is a part of the process of memory, of state-sanctioned memory in particular. And then it's fascinating that this whole discussion takes place. To me, I'm not a legal scholar, and I'm not a historian of the Holocaust, so feel free to correct me. But it's taking place in a context in which I would argue that there's a revisionism. So Holocaust studies, even among liberals in the West, is becoming genocide studies because you can't be particularistic. So there's a sort of liberal, postmodern push in the West to put Holocaust in its proper place. And then you have the sophisticated historical revisionisms of people like Tim Schneider, who, instead of looking at the Jewish experience during the Holocaust, takes a geographical perspective and puts the Holocaust into a context in which other people were also brutally killed and treated. So the Holocaust is structurally changed as not being unique, but part of a mass killing of that period. So to me, it's a very sophisticated and a very dangerous form of historical revisionism, which is gaining traction in places like Poland and the Baltic states, and in places like the Ivy Leagues in this country. And this sort of becomes a liberal approach to the history of the Holocaust, and it's intertwined with the histories of Polish victims and slaves and migrants and people who were forced. The uniqueness is being watered down. And even in your discourse, I found that to be part of it. So it was all intertwined with other people's and other people's suffering, real suffering, but the uniqueness is going away. And then, if you step out of that context, which you did, and you touched on it, then there's this sort of crude, Islamist, Arab nationalistic, I would say anti-Semitism, which is, an attempt now to murder the history of the Jews, to take away the voice of the Jews. In a sense. So it's fascinating. And then where's the Jewish history, where's the history of the Holocaust in all of this? And just as an antidote, I'll say I was recently in Auschwitz. I never wanted to go there, and I went. I had to go, so I was invited by some people, and I went. And I was struck, given my understanding of the history of that place, how it's being turned into a place of Polish history, of Catholic martyrs, of Polish heroes, and less so, I thought, in my reading and my experience of the Jewish history, of the history of the Holocaust, which is playing to the Polish and Eastern European people who come there. So that was striking to me, that was shocking to me. And then, of course, walking in Bergen-Belsen, and I was with one of the leading tour guides, and we were walking, and she said, look at the earth. And I looked at the earth, and it was gray earth, and she said, you see the white specks in the earth, and there's hundreds of tourists walking where we were walking. And the white specks are bone fragments that the incinerators couldn't destroy. And people are walking to the museum over the ashes of my ancestors. You know, that is the monument. That's a UNESCO protected, international acknowledged monument in which people are walking on the victims' remains. So to sum up, you know, to make the point, you know, so memory, you know, so I wonder if we're in a position now where monuments and European states and laws and discussions and discourse is so far removed from memory. And I think the lesson isn't simply to remember the Holocaust, the victims of the Holocaust, or other genocides and other catastrophes. The lesson must be to protect the living people. And we're living in a context now where the discourse of the demonization of the Jews, and there was a fascinating lecture last night where the philosopher was talking about the language of signifiers. The signifier is, you know, the bad people are the Israelis. They're no longer the Jews. You can't say certain things about Jews, but you can certainly, and you're encouraged in many contexts, to speak about Israelis as we used to speak about Jews. So I think the challenge is not simply the memory, but the challenge is how do we protect the lives of living descendants of Jews and other people who have been oppressed. That, to me, is the challenge of law and the challenge of the scholars, in addition to memory. So, comment as you wish. It's a disjointed comment. I don't know if there's a question in it, but feel free to respond or take a question.
Yeah.
Do you know what percentage of schools no longer teach about the Holocaust in Europe?
I'm not aware of research on numbers, but these were more like individual cases in Italy, in the Netherlands. But I know now that the European Commission is making kind of a study on such cases. And they want to actually to count in how many schools, what percentage of schools have this problem.
I'm going to put it. Could you respond to some of the points I raised?
Yes, sure. Well, I agree with most of what you said, but I think that it really matters how we deal with the memory and the past, also to be able to protect the Jewish people, the Israelis, as you said, which is now like the issue of the most important concern. And about this, what you said about Auschwitz, we had this conversation before. Well, I think there is a competition of memories, and the Poles, for many years, as I said, under this oppression of Soviet and communist regime, were not able to exercise their own memory. So maybe this is a sign of Poles wanting to underline their own sufferings, and that Poland was also a victim of Hitler and the Second World War. But of course, I think that Auschwitz should stay forever the symbol of, first of all, the Jewish Holocaust and suffering. I have just been to the Holocaust Museum in Washington, and here you're right that the Jewish perspective is so obvious there, which is not the case in Poland. But going back also to the exceptional character of Holocaust and the way we should try to save it, there's an interesting example of the European Court of Human Rights, which in all cases of Holocaust denial or cases dealing with the Holocaust past, stands on the position, and which is actually not the position taken on other cases of historical events, that the limitations of freedom of speech or association or assembly are accepted to a really broad extent when it comes to Holocaust deniers, like the European Court of Human Rights allows for the limitations of freedom of speech imposed by the states on Holocaust deniers. because the European Court says that the Holocaust is like the exception, that we can never deny it, or it will be never allowed to deny it. So I think this is like a positive signal in the things you mentioned. And this is what you said at the beginning about the monuments that become more about the perpetrators. So this is the case of Germany, in my opinion. And it's really also from the Polish perspective, it's dangerous and worrisome. Like this center, this huge center of expulsions, and the whole movement behind it. And their fight is to make the sufferings equal in a way, that the German sufferings, which were of course the case also, but this aspect of the reasons for the expulsions and German suffering is missing there. So I think this is really dangerous and worrisome.
So I'm going to ask Jonathan.
First of all, thank you so much for being here today. I really appreciate it. I had a question just in terms of the sort of the exceptional, the nature of the Holocaust being exceptional, and that sort of notion. In terms of what do you can you sort of articulate what exactly defines that exceptionality? Is it the actual perpetration of the act? Is it sheer quantity of deaths, or is it sort of the memory denial and loss that occurred afterwards? So what part of the process truly makes it exceptional, or is it the entire summation of sort of the post-Holocaust reaction, the during the process, and what led up to it? I'm curious in terms of a personal note, also but also in terms of what the general discourse is on why it is exceptional. So,
I think that all the elements you mentioned are very important in seeing this exceptional character of Holocaust. But for me, it's mostly the question of the grade of this, what happened. And from the legal perspective, the implications of today, the anti-Semitic motifs, which were the reasons, one of the reasons why Holocaust happened, and which are still to be observed today. So the risk that the new Holocaust will happen is still, I think, a valid question. And so I would see the exceptional character of the Holocaust in this whole, on the whole scale of genocides, like something what was really the only one in history, and also the scale and the whole mechanism. The ideology which stand behind the Holocaust, that it never happened again with other genocides. So I would see this exceptional character here.
Just a follow-up question, just a brief question about, in terms of genocide at large, sort of, is there any harm or fear in that by deeming one genocide sort of being sort of very exceptional compared to the others, is there any harm of sort of perpetuating that trend, in that like future generations will want to or will be encouraged to make the more exceptional genocide that will stand out even more in the history books? In terms of the recent gun control debate, people often mention that the fact that the media sort of plays it up to plays up the story of the person who killed the victims, that actually leads to further shooters, because that encourages and kind of perpetuates that story and makes it very sensational. So is there any fear in that there might be a backfire from not sensationalizing the Holocaust, but making it the exceptional genocide? I'm just curious as to whether you fear that, or is there a fear of that?
Well, I didn't think actually about such a connection and such a danger, but maybe there is, but hopefully not. But the examples of genocides which happened after the Holocaust, I think they have not a lot in common with this will to make something even bigger or more. I don't know how to describe it. Well, something what would be even better, bigger and more drastic than Holocaust. So I wouldn't see this, but I think.
I just wanted to comment on something that he said. A lot of the genocides that have been committed have been committed in the name of Islam against whatever culture. So, I mean, during World War II, the Holocaust and the murder of Jews, the extermination of Jews was extraordinary because so many people died so quickly. But in Sudan, we've had 3.5 million people killed over the last 100 years, and those are Christians being slaughtered by Muslims. And it doesn't get as much press because it's been done over 100 years. Now, we did have 1.5 million Christians killed over, like, say, Mogadishu over a few years. It doesn't get the same amount of press. And of course, what happened in Armenia by the Turks, and that was an Islamic, Muslim genocide of Christians in Armenia. And, after the partition of India, where we had India and Pakistan, all the Hindus and Christians that lived in Pakistan were slaughtered. And, I know that many of the Hindus that lived in Pakistan, they were just thrown onto train cars and just, they just rode back, just dead bodies driven back into India. And those were hundreds of thousands, if not millions. So, to answer your question, I think it's just more of an awareness of what Islam is. And you just can't forget that. And I think people are trying to portray Islam as something else. I mean, if you don't talk about it, people don't know what it is. I mean, I don't know if you would disagree or agree with me or not.
You want us to speak our question?
Oh, well, he had asked the question, and I was responding back to him.
Okay.
Well, I was in Terezin a few years ago, which was supposed to be like a camp, this ideal place. And I felt that it was not tainted, that it did give you a sense of what the Holocaust was and that we should remember, which made me feel sad, of course, but also that it was appropriate. And I was also in Germany around the same time, in Berlin, where we were taken on a tour of the Jewish section and told all these wonderful things about how Jews survived. We went to the synagogue, we went to places where they lived, and we saw statues and sculptures, and it felt like they were not whitewashing, but apologizing. It wasn't about the perpetrators, but it was like, look, we like Jews. See, we like them. And I didn't really believe it. It didn't feel true. But the other thing was the education in the United States now is changing. I work with small children, and they don't even know what the Holocaust is. It's not in the books. It's not discussed. A lot of multiculturalism is discussed, recipes and things like that. But is that true all over the world now, where it's not even discussed in the schools?
I'm afraid to the larger and larger extent it is the case, yes. But of course this is problematic that children here in the US do not know about the Holocaust. But for me it is especially shocking that children in Europe, like in Italy or United Kingdom, don't know about it or their parents refuse them to know. Like in the case of Muslim minorities that I talked about it, there are cases when they protest against Holocaust lessons on Holocaust because for them this is simply a lie and they don't wish their children to find out about the lie, so it's a Jewish lie. So this is highly problematic and worrisome, and I would be afraid of the direction in which it goes, because when such cases are to be found more and more often, then we have a real problem. If the people in the countries where the Holocaust almost happened, they don't know what happened 70 years ago.
Can I bring back a legal perspective to it? Because I'm a lawyer, more specifically a constitutional lawyer, And I think that when we talk about what you call memory loss, it would be good to at least assume that there is something prima facie bad or at least problematic about them. That is that by their very nature they try to regulate things which we liberal Democrats believe that unless there are very strong reasons to regulate them should be left to the sort of free market of ideas. So that the state telling us, sometimes even under the sanction of penalty, what we have to think and talk and how we should understand the past, there is something presumptively wrong. In the end of the day, it may be necessary to have it, but the burden of argument is on someone who would argue for such memory loss. I think that's the starting point. And if we accept that starting point, I would like to refer to a distinction which you made right at the very beginning of your paper, the distinction between laws which I think you said create certain official orthodoxy about the past, that's how to understand the past, and on the other hand, without any sanction attached to it, without any penalty, and on the other hand, laws such as genocide denial or Armenian genocide denial or sort of all sorts of, especially I think French laws which attach specific penalties to the falsity, according to the lawmaker, about a particular event. And I think that the sort of general assumption is that those former laws are somehow less problematic, like your example of Spanish, because at least there is no penalty there. And I just would like to say that while we concentrate and focus here on the Holocaust denial and laws like these, it would be good also to think about certain pernicious effects of the former types of laws. And I can think of all sorts of official authoritative pronouncements, which, especially in post-communist laws, which I happen to know reasonably well, including constitutional laws, which try to create certain official orthodoxy about what communism was. The actually Czechoslovak still law on lustration and decommunization defined, not just in the preamble, but in some of the actual operative articles, communism as a reprehensible, illegitimate and criminal system. And now the most recent Hungarian constitution of 2011 makes all sorts of statements about communism. And I think that these, thinking about what's wrong about these laws is important to reflect more generally about memory laws, because these laws usually, even though they make statements that most of us would believe are sort of like unobjectionable, nevertheless they are always part of certain political battle, of certain political competition, and they usually are a tool of the lawmaker or whoever controls the legislation to somehow defeat or weaken or disable their opponents. So perhaps one way, just to finish my point, one way of distinguishing between different laws is about those laws which specifically tell about certain past facts, which perhaps are less problematic, like Holocaust denials, and those laws which attempt to impose certain interpretation, to tell us how to value or disvalue the past, which inherently are not just dangerous to freedom of speech, but also are very social divisive.
I'm sorry, can I just get a little bit of clarification? So do you support like the teaching of certain historical facts, or are you opposed to it? Do you believe the free market?
No, of course not. No. That's why I begin by saying that I'm not talking here about teaching, about education, about, say, public discourse. But I'm talking about the law, about the law trying to tell us what to think. Not schools, but the law telling us, the legislative act telling us communism was this and that. This happened, you cannot deny certain things. Sort of imposing certain privileged perspective on the past. And that happens. That's also part of memory law, especially in post-communist world. And that is, I think, something very dangerous. Of course, we cannot be neutral in the education about the past. But I think when it comes to legal pronouncements, we should try to stay out of making this type of declarations and assertions as much as possible.
I agree that this very often becomes a part of a political fight or the competition competition of memories between different political options, and this is dangerous. But the most dangerous point is when the criminal law comes with those provisions, I think, and it should be, in my opinion, legitimized to include criminal law only in cases when, for example, Holocaust denial incites hatred towards Jews and is a manifestation of anti-Semitism. Then yes, but in other cases I would be very, very careful with criminal law sanctions.
So Chuck, and then
It's a clarification about the level of knowledge or lack of knowledge that you were talking about before in the U.S. and Europe. Is it less, or actually maybe it's even more than? Do we have statistics? Because it's the fact that it isn't very well known. I'm sure it's true, but how does it compare to the past? I think in the U.S., for example, huge numbers of kids are taken to the Holocaust Museum in Washington. And maybe the level, again, I don't know, maybe it's actually greater today than it was in the past in the U.S. How does it stack up if we have the figures in Europe? And I would also just make one distinction between the general European population and the Muslim population, because the Muslim population, the others may simply not know. The Muslims are specifically making a decision not to know about it because they think that it plays in Israel's favor. It justifies Israel's existence, and so it's a political decision, actually.
Yeah,
Well, it's not just Europe. I mean, that the whole argument that you're talking about is going up. Sorry.
Well, I don't know about the education and numbers you're talking about in U.S. Specifically, but I know the example of Germany pretty well. And just after the war, the level of knowledge and the education was also very low, and they were not speaking about it.
Right.
Only after some period of time it came again, and the generation of, I would say, people who are now 45, 50, they know a lot, and I think they struggle themselves with this issue also. But the most problematic and dangerous numbers come now with this youngest generation, 18 years old to 30 years old, as the poll I mentioned here in the paper shows. 21% of young Germans, I think, haven't heard the name of Auschwitz. Well, I think it's shocking in a way.
That's amazing.
There was a prior question on the uniqueness of the Holocaust. Isn't the industrialization of the Holocaust doesn't that make it unique among genocides?
Of course, yes, I would strongly say yes, which is one of the elements of the whole unique character of Holocaust for me. Of course, in the case of Rwanda, for example, one can say that they didn't have, brutally say, they didn't have the tools to do it on such a scale and in this way. But I think it was the element of the whole concept of Holocaust before it happened that it happened in this way. So yes.
What about the use of the term Holocaust, where it seems like legislators are using it for all kinds of things? They're calling people, they're saying that people are conducting a Holocaust that's completely irrelevant.
But I figured legislators don't do that in the terms of law and in the
not in terms of law, but in terms of discussion and
yes.
Insulting someone, saying that they're creating a Holocaust when it doesn't
You
compare.
mean with other cases, like, for example, the Holocaust of animals, or yes?
Yeah.
Well, there was an interesting case in the European Court of Human Rights when the organization fighting for the rights of animals wanted to make an advertising campaign with the posters showing meat on the plate, saying the Holocaust on your plate. And European Court of Human Rights said it's not allowed to do such things, and that this is something done against the memory of the victims and dignity of the victims of the Holocaust. But you can see more and more of such examples when the Holocaust name is used for all kinds of tragedies, like from the something what happens to animals, for example, or the Holocaust of all other groups which have been discriminated, or so this is a problem.
And how does this turn into your argument? Is this, what are the legal implications from your perspective?
Well, it's an interesting thing for me. I mean, it is very, very problematic to somehow trademark the word Holocaust. I think it's in a very bad taste to talk about Holocaust with respect to anything else than the Shoah. On the other hand, I'm very reluctant to allow the legislator to trademark certain words and say the Holocaust can be used only, legally speaking, in this particular context. Little bit like, the Olympic Games cannot, people cannot use the Olympics because the word is trademarked. This is the question of basically freedom of speech. If some people use tasteless arguments, it doesn't necessarily mean, or tasteless language, like the Holocaust of animals, to sharpen our sensitivity towards suffering of animals. I think that these people perhaps should be condemned, but I don't think that it's a matter for law to intervene.
A question and an observation. By saying that you want to restrict, be very careful with memory laws across the board, except for the Holocaust, don't you run the risk over time of people pointing to that as saying, you see, they've made an exception for that, and that is being used as a tool, as it's being used in other ways. So, you begin to carve out exceptions, even though they may be ethically justified, you run risks of being pointed to later as proof of the need to do that, or using that for some nefarious purpose. I don't know how strong that is. And the second thing is, I think traditionally in Judaism there are memory laws without criminal sanctions associated with them. For example, the biblical law of remembering what Amalek did, and other holidays that celebrate events like that. So there are memories, but there are no criminal, fines associated with failure to do so, or to apply them in some way. What do you think about my first point, my first question?
I think that in all cases when denying genocide is aimed at spreading hatred towards a particular group, the group of victims, then the criminal law sanctions may appear. So it's not only for the Holocaust denial, although it is proved with numbers that most often and almost always Holocaust denial is disseminated in order to incite hatred towards Jewish people. This is why this is also like an exceptional example. But if denying the genocide which happened during Bosnia and Balkan War is also aimed at inciting to hatred and inciting to violence, then also yes to the criminal sanctions.
So are there any? So what are the legal implications? So the new Secretary of Defense in the past, of this country in the past, wanted to reach out to Hamas, Hezbollah, Iran, and other organizations or social movements in the Middle East who argue that the Holocaust is either an invention or was exaggerated to justify the colonization of Muslim land and the occupation of all of Palestine. From Tel Aviv to Judea and Samaria. Now, are there any legal implications from your perspective if, let's say, the United States of America engage with these people, make treaties, make arrangements, agreements, enter into all sorts of, and these parties have these perspectives, and they, from our perspective in this room, they want to harm the Jewish people. They're using the Holocaust as a tool to harm the Jewish people. What happens if third parties enter into agreements with these people who are intent on harming the Jewish people using the Holocaust in this way? Are there any implications?
I think more of a political nature.
Not legal?
not legal. U.S. is a party to the International Convention on Genocide and on elimination of all forms of racial discrimination. And in this latter convention, it is said that the state is legally binded to, for example, to make a ban on the existence of the organizations which spread hatred towards ethnic, racial, minority groups. So, but this is like the, not the distinction which would make, I don't know, the United States responsible for any violation of international human rights law. I don't think so.
Any other questions or points?
I came in here this evening thinking that I know what the word Holocaust or genocide means. And I'm not sure I know. Not through any fault of yours today. Because the Holocaust was 6 million people. How many were killed in the Armenian genocide?
1.5.
Was it 1.5?
Yeah.
Okay. I thought it was much lower. This gentleman gave an example of 3.5 million people over 50 years, or
100 years.
100 years
in Sudan. And
okay,
then I think
that's one example. So what now? Rwanda was how many people?
500,000.
500,000.
No,
800,000. Cambodia was to 2 million. So I don't know. What's the difference between mass murder and genocide? I think is what I'm asking.
There is a legal definition of genocide.
Not legal. What do you think the definition?
I wouldn't go here in the direction of numbers, I think.
Okay.
And all of those crimes are genocide because of the also legal definition of genocide. And the motivation standing behind them. But as I said, the current implications of the Holocaust are, for me, also one of the most important elements which distinguishes it and makes it unique. So, but I cannot.
Let me ask you. I guess I didn't fully explain. Stalin killed how many tens of millions of people?
Yes.
It was 20 million.
20 million died in the Second World War. How many did Stalin kill? 20 million. Okay. Mao killed how many millions?
It was estimated 20 million.
Was that genocide?
Now, again, the legal nature comes. Well, if it was motivated by the ethnic or racial hatred, then
so it's got to be motivated by ethnic hatred to make it a genocide.
No, but I think that even commonsensical understanding tracks a legal understanding. Genocide is an attempt to eliminate the whole nation. You don't want that particular nation to exist. I don't think that Cambodia was the case of genocide. It was mass murder, because it's difficult to imagine that Pol Pot wanted the Cambodians to cease to exist. But Hitler wanted the Jews to cease to exist. So if it's a murder committed to annihilating the whole nation or the whole group, this is genocide, both legally and commonsensically. Everything else may be even worse in terms of numbers. But Stalin didn't want Ukrainians to cease to exist through the hunger, or the Russians to cease to exist. So it wasn't genocide. It was mass murder.
It's just a small point. In terms of numbers, and I agree that numbers are not the criterion here, most people think that the Holocaust actually killed about 11 million. There were 6 million Jews. And without the Jews, there wouldn't have been a Holocaust. And there are other features that make the Shoah, the Holocaust, different from other genocide. In particular, it has to do with the mobilization of all of the resources of society at all levels to do this, not just as some kind of outburst or demonstrations or riots that happen across the country over a short period of time, but it was a sustained effort over a period of several years. It was an industrial operation. And there are some unique features.
So, first of all, thank you everybody for coming, and a great discussion. And Alex, thank you for a wonderful paper, and nice to see you again here.
Thank you.
And continued success in all of your work.